Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, my name is Justice Maduforo. I am a solicitor of the Senior Court of England and Wales. I'm also barrister solicitor of the Supreme Court of Nigeria. Ladies and gentlemen, Tice Madox Solicitors has poised itself to represent you in your best interests. And that is our cardinal goal, to represent you in your best interests, ranging from matters in immigration, criminal law, employment law, contract, landlords and tenants, litigations generally, matters in the county court, matters in the family court, matters in the High Court of Justice, from magistrate court all the way to the Crown Court, magistrate court all the way to the Crown Court, and from the county court to the High Court, Court of Appeal, and all the way to the Supreme Court. Ladies and gentlemen, and this firm, Tice Madox Solicitors, has legally to represent you at the police station free of charge at the police station all the way to the Supreme Court. Ladies and gentlemen, it is important that you take cognizance and take into account what we do. And now the presentation today is to bring your consciousness, reawaken your consciousness again on the fact that your rights are fundamental, and it's important that you take action when it comes to your right, or when it comes to even obligations that are owed to you, not just by the state or by other parties. On that note, ladies and gentlemen, I have brought diverse topics and I've discussed this on this program. They are not legal advice. Therefore, before you must act on what you hear me speak on this program, you must come and seek proper legal advice before you can act on what I speak on this program. On that note, I will be discussing immigration. I will be discussing immigration today. Why immigration? It's because it's a very crucial topic. And by popular demands of most of you who have emailed us, and that's why I'm discussing this today. And because the emancipation of your status in this country determines your success in this country. And therefore it's crucial, because if you don't have your immigration status, employment will not be important. And therefore, that is the case. And if you don't have immigration status in this country, if you commit a criminal offense, it becomes much more severe for you. So therefore, immigration is crucial. But obviously, it doesn't affect you only. This topic may be for your words who do not have leave to remain. Your children, your father, your mother, your sisters, your neighbors, your friends, your work colleagues as well. That's why this topic comes your way. Today, I will be discussing immigration administrative review. Immigration administrative review. Now, administrative review was introduced by the Immigration Act of 2014 by the Home Office. And this came about which corrects decisions made by the Home Office in respect to point-based system applications that you lodged. Point-based system applications, Tier 1, Tier 2, Tier 4, Tier 5. These applications that you lodged, and it was refused by one reason or the other of the Home Office, and then you were now given administrative review, the right to administratively review the decision of the Home Office. Some of you are taking advantage of that. Some of you are doing that. But recently, I have received enormous applications refused from people who have watched this program and they've come to the firm to help rectify that application, help rectify that decision. And because some of you have made these applications yourself, and I'll talk about that briefly, or some of you have made this application to representatives, previous representatives, who did not understand or who did not take proper legal consultation from you, or proper legal consultation instructions from you. And they did not take that instructions from you, and they did not marry that instruction in line with your circumstance, in line with the case laws, in line with the policy and guidance of the Home Office. That application was refused. And obviously, you now have to seek for alternative, because that may bring doom and the end of your immigration journey in this country. And you've come to my firm, and I have put a signature touch on it to rectify it through administrative review. Administrative review is crucial, because once you miss it, then that means that the period you stayed in this country on point-based system, Ruth, which means they are now coming to nothing. The administrative review came into force, as I said, through the introduction of the Immigration Act 2014. Having introduced that Act 2014, the implementation of whether you will be granted administrative review rights or you'll be granted right of appeal started for those of you who lodged a Tier 4 application, Tier 4 general applications. It started from 20th of October 2014. Those of you 2014 applications, after applications you made from October 2014 upwards for your point-based system Tier 4 application. Once that is refused, that means that, and you lodge the application before October 2014, then you will be given the right of administrative review. That will come in the letter of refusal to you, and detailing the reason for the refusal of your point-based system Tier 4 application. So those of you who are applying under the point-based system Tier 1, Tier 2, and Tier 5, the introduction and the implementation of the administrative review came into force from March 2015, which means that any application you lodged from March 2015, which was refused under the point-based system Tier 1, Tier 2, Tier 5, then that means that you'll be given administrative review rights. But if your applications were lodged before these dates are mentioned, then you have right of appeal. They are not the same. Now, why did the government introduce administrative review? Now, because over the years, before the introduction of the Immigration Act 2014, and from October 2014 and March 2015, there has been a surge of appeals refused under the point-based system by the Home Office, and individuals and the applicants have taken their matter with right of appeal to the first-year Immigration Tribunal. And they have gone in there and they began to introduce new evidence which was not there when they made the first application. So that worried the Home Office that a rule was put in, and this Immigration Act 2014 was proposed, passed into law, that no longer gives you right of appeal, but gives you, therefore, from applications made from the period I mentioned, administrative right to review. That administrative right to review is to, on certain criteria of which the Home Office caseworker must have made an error. Now, having said that, the Home Office themselves continue to review that error of administrative review to ensure that decisions they made or made by the administrative caseworkers were correct decisions, and they did not infringe into your right. They did not mistakenly or erroneously refuse your application under the point-based system based on the error of the caseworker, based on whatever the caseworker was looking at or was thinking at the time they made the decision. Now, that is the position. The administrative right to review that decision of the caseworker, of that right to review that decision of the caseworker who is a representative of the Secretary of State of the Home Department, becomes a decision made by the public body, which that if that administrative review is refused again, then you have to look at whether or not you have put in enough points to judicially review that administrative decision. Let me clear the point. Now, as I said to you, this is not legal advice, but it is to bring your consciousness alive and you to take proper legal advice in the right firm that is robust and that is thorough to ensure that your administrative review succeeds. Now, before we get to administrative review, it's important that you lodge the application properly. As I said to you, 80% of applications that have come to me that was refused under the point-based system and was given rights to administrative review came from individuals who lodged applications themselves. And because they lodged applications themselves, they completely ignored the warning signs, the red flags that have been on there when they were completing this application. And as a matter of fact, the Home Office is very easy for them. The caseworkers is very easy for them to make a decision refusing that application. Because these applications look so simple before your eyes. You just tick your name, date of birth, people just assume they're getting it right. Yes, fantastic if you get it right. But as I said, the statistics is not in your favor, which means that 80% have been refused applications under the point-based system and given right to administrative review because the first initial foundation the application was made was rough and forth with errors. And obviously, not only with errors, the individuals or the applicants themselves have shot themselves in the foot when they lodged in certain documentations in that applications without properly properly taking legal advice to ensure that the document they submitted in addition to the application for the point-based system, either for extension, either for indefinite leave to remain, or either for first-time application on either all the points or the tiers I mentioned. And in that respect, made grievous errors. And those errors, guess what, can never be rectified. Which is why we present ourselves as the best firm with eagle eye, with understanding of the requirement, and to scrutinize the document, to scrutinize your instruction, to make sure in your best interest that whatever is packaged in there, presented in there in the first instance succeeds. But that is the first foundation, which is the tier 4, tier 5, tier 2, tier 1 applications. Or your indefinite leave to remain through those tiers. Most of you have stayed on the point-based system, either tier 1 or tier 2 or tier 5 or tier 4, consistently up to 5 years as the rule requires, and you are not eligible to apply for indefinite leave to remain. But guess what? Some of you, when you've launched this application, from the first time you've been applying and renewing and extending, you've actually been shooting yourself as you go along. That is the situation. Now back to administrative review. Once decision is refused, then you're given that right to administrative review. The administrative review is to correct certain fundamental errors made by the caseworker. But 80% of yourselves, whom application of that nature has been refused, could not flag up any error. But most importantly, the decisions by the caseworker to refuse that tier or the point-based system applications or your indefinite leave to remain application, most of them has boiled down on dishonesty on your part, deceit on your part. That has been the critical point of majority of refusals for your point-based system applications. What am I saying? Let me put it this way. Your applications under the point-based systems, as you go along, some of you make up documents, some of you make up figures as you launch these applications, without understanding that you have a strict liability on those documents, and you have the sole responsibility of the documents which you submit to back up the application, both for indefinite leave to remain or for other tier point basis. So it's crucial now that you understand the documentations you put in will either aid you or destroy your application. But Tice Madox Solicitors are here to ensure that when we launch this application for you, you can sleep soundly. You can sleep soundly with expectation, with a legitimate expectation of a successful outcome. On that note, I'll take a quick short break. I'll return in a while, and I will give you even the greatest shocker. Don't change the dial. I'll remain Justice Maduforo.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello. Welcome back. I remain Justice Maduforo, your preferred solicitor, and under the preferred firm, Tice Madox Solicitors. Today, I was discussing, and I have been discussing, immigration administrative review. Before I took a short break, I did inform you that you stand a chance to succeed in your application for your point-based system application. Then, when you have erroneously or intentionally, or either advertently or otherwise, inadvertently, or whichever, whether voluntary or involuntary, directly or indirectly, lodging documentations in that application, which is now the subject and the subject matter for refusal. And the problem is that if this document you presented are documentations that are forged, or that on the face of it intends the caseworker to believe it to be genuine, then the problem is, once it is identified, then that's where the difficulty lies down. The house and the pack of cards will crumble. What do I mean by that? Some of you, the first time you've come into this country and applied for instance, on the tier 4, on tier 4, you carried on tier 4, keep on renewing under tier 4. And you keep supplying cast documents or cast letters from your college or universities that you choose to attend. And those cast letters, either genuine or ungenuine, or not genuine, they have been presented to the Home Office. Second fundamental problem is that you have also presented, in addition to those applications or to those tax letters, you have backed it up with bank statements that shows that you have the financial requirement to meet the criteria and to meet the points. And you backed your application up with those letters, the bank statement, either those that are within this country or those outside this country, either in your name, more especially in your name, from outside this country, and showing that you have the resources and the funds to fund your Tier 4 application going forward. Either the first time you're making that Tier 4 application or the second time. Now, that also applies to those of you who also applying on the other tiers. Under the Tier 1, and you have also backed up documentation to show the application is genuine. Or those of you who are also going through the Minister of Religion's route, and you have also presented documentation to show that the ministry or a particular religious organization have admitted and accepted and sponsoring you. And not knowing that either before you lodge the application, the sponsorship must have been withdrawn, or is fraught with error, or has been withdrawn even when it's been given to you. Now, back to the information, and back to the issue about documentation, especially financial documentations. And this is where 95% of your error lies. And what about documentation am I talking about? The bank documentations and financial documentations which you put in might either be that of your bank or maybe from your accountants. Your accountants, some of you who are self-employed, and most of you are. And I can tell you, yes, most of you are. Either making up to the figures which you need for you to be entitled to the application which you're lodging. And you have made up and kind of blowed up the figure through your accountant's report. Now, some of you are crying, and you're watching me right now, and you know that you're sitting in such a situation. And either you've applied for administrative review, or you're about to apply for administrative review, or that you have applied for your indefinite leave to remain or extension of under the point-based system, but you're still waiting decision. And you can clearly understand from the sound of my voice that your document, the document which you presented, financial document especially, and more particularly now, report from your accountants. And then you have submitted that and believing that accountant report is believable. It is not the way it is. In certain circumstances, the Home Office understand and accept that. Grant you your application for the first time, grant you the second time, grant you the fourth time, then the fifth time, you're now applying for indefinite leave to remain because you have not stayed in the country for 5 years under that route, and then you're eligible to apply for indefinite leave to remain. Then you are excited, and then you submit your application. Guess what? The Home Office caseworkers pass your application, revert back to the other previous applications you've made, the first one, the second one, the third one, and they begin to look at documentations you submitted. And they begin to contact the agencies which you have provided them to be genuine from, and that your representation of the real facts which you have submitted. And especially, they begin to contact the Her Majesty Revenue and Custom, HMRC. HMRC begin to give different figures to the one you presented to the Home Office. Now, Home Office will just leave you, and the decision is very obvious, meaning you will be refused. And the problem here is that the refusal will be on the basis of deceit and dishonesty. That is very much catastrophic than just ordinary refusal. Refusal under dishonesty or deceit, that is catastrophic because it has a lot of adverse consequences, which means that it may completely stop any further application you make in this country going forward. That is why we present this topic to you. That's why I come and speak with great emotion on this topic and on the things I present to you to kickstart your consciousness to do it right. When you come to the firm that know how to do it right for you from the first time, the foundation is secure. But when the foundation is shaky, whatever thing you are building on top of it, even when you are smiling on the way that you have been able to save funds by not going to solicitors to pay the fee to do that for you, you've got the first decision, second decision, fourth decision, you are now waiting for indefinite. Pause there. That is where the Home Office will revert back from the beginning and will unravel those errors you think have not been overlooked. They're not overlooked yet. They stay on the record. And it depends on the caseworker who will go to bring them out and match them up with the official records. When official records are not matching and not tallying together with what you have submitted previously for your application, which means, number one, that you're not even entitled to the first leave that were granted in the past. that will be revoked. As it will be revoked, you do no longer meet the 5 years long residence continuously for you to be eligible for indefinite leave to remain. That is a difficulty there. Now, going forward, because there's a lot to discuss in this matter, the essence of it is that you should not make such applications. If you are due to apply for indefinite leave to remain through this point-based system I mentioned, pass there. Come to Tice Madox Solicitors to thoroughly prepare for you. And you will smile all the way. You'll be comfortable. You'll be convinced that at least you are much consigned and much believable that your application would definitely be granted. And you will not have a difficulty going forward because you have stages. You're on a journey. The first journey is the first of the limited leave you get. You apply for indefinite. The final journey is for a naturalization. Guess what? Under character, conduct, criteria of the Home Office, in decisions of indefinite leave to remain, in decisions of naturalization, will catch up with you. And which means whether you're convicted in magistrate court or not, for criminal offense or not, the fact that they have flagged up the dishonesty and deceit, that will shut down your application going forward. The essence is that you do not take that route. You spend enough years in this country in order to just collapse it for no just reason. Start properly well. Start in a good state and end it well. And that's what Tice Madox Solicitors will do for you. Guide you all the way. Scrutinize the document. I have the eagle eye. I have the strong mind, legal mind to look at documentations and spot the difference. I'll be able to send you back to correct it in your best interest. By the time it's corrected, you will smile all the way. But guess what? Do not leave your application to the dying minute. That's what I've come to realize most of you do. Your applications, you leave it there. 1 week to the expiration of your application, you begin now to lodge applications and fit in documentations that are not appropriate. And then you are just killing yourself the more. Start your application a month's time, 2 months before that. Seek proper legal advice. Come to us. We will guide you all the way. Provide what you need. And then lodge the application when you're due to do it. And the application will sail. Then, as I said, the topics are administrative review. Then when you do this thing wrongly and it's refused, you give him administrative right to review that decision. Why? That is where the fundamental issue comes in. The fact that you have right to administrative review is not a guarantee to your success. When I look at your document, I'll be able to tell you that you have a chance or you don't have a chance. The Home Office have been giving guidelines on how to deal with administrative reviews. But yourself, who is applying for review of that administrative decisions, you have to point the issues which the caseworker got it wrong. As I said earlier, if your application falls under false documentations or deceit or dishonesty, that is a very much crucial point. And at that point, you find it difficult going forward. But no hope is lost if you are in that category. You have to return to Tice Madox Solicitors. We will unravel whatever is done. We will use the case laws, the statutes. We use the discretionary power of the Home Office. We will unleash the law on the Home Office and direct them and inviting them to reconsider a decision. Rather, in this instance, repackaging that decision for you. Not the way you think you're going to write. Some of you write is a common way, but we're going to pack it up in a legal way, in a more legal, in a more forceful, more convincing, and more changing manner when we launch judicial review, administrative review for you. But guess what? Even if administrative review is refused, you've got the right to go for judicial review. But we don't want to get to that stage yet. We want to, first of all, kill it at the first stage, which is the time you make the application. But if you're not by any means, one way or the other, you did not able to find us or contact us, and you've done that, and the error is now unchanged, then you have watched us on the program. You can come to us to take it from the judicial review stage. And we will repackage and take detailed instructions from you and put the application to succeed. Now, what happens when you apply for administrative review? Some of you have difficulties. Either you've stayed here up to 10 years, but you've applied under the 5-year criteria, which is your indefinite leave to remain on the basis of your point-based system level, or period. You've been here. Now, you know that you are sitting on that position whereby false information, or you're not due, or you're not entitled to the applications you made in the past, or errors have happened. Then in that case, the question is that some of you think you cannot jump to make 10 years rule application. When you come to the office and seek proper advice, I'll be able to tell you whether your 10 years route you were expecting to run through in the event 5 years is refused, whether you can go and start on 10 years. I will advise you going forward in a proper way so you can understand that whether you have a case going forward or you can, at best, shut it down. We will advise you, take you through those processes, ladies and gentlemen. And what is your right to stay in this country when an administrative review has been lodged? Now, the rule also provides under Section 3C of the Immigration Act of 1971 that you continue to stay based on your old rules and decision is made under the administrative review provision or proviso. So once the decision has been made refusing you, what happens to your right to continue to remain in this country? Is it shut down? Is it curtailed? Is it extinguished? Is it stopped? When you go to judicial review, what happened to your right to continue to stay in the country? Ladies and gentlemen, these are the things you seek when you come to seek proper legal advice. State by state basis, I will take you through to the demerits and demerits, advantages, disadvantages, how you can overcome this as we go along, what your rights are, where your rights fall due, and when your right extinguishes, and when you come to the end of the road, and when you can start to a new set of the roads. We will guide you all through as you go along. I'm discussing today Immigration Administrative Review, ladies and gentlemen, and I've introduced to you that 2014 Immigration Act introduced it. Now, guess what? Immigration Act of 2016 have just recently received the Royal Assent, have also come to consolidate the Immigration Act of 2014, and in respect to the 2014 and in respect to the administrative review, which started from October 2014 and March 2015. Now, afterwards, that is a procedure of which administrative right has carried on. Now, let me also shock you that when this 2014 Immigration Act came into place, the Home Office Commission, that act provides for a review of that judicial review to see whether errors or misplacement or miscarriage of justices have taken place during those administrative review period, whether they have been ignoring certain things and refusing certain things. Now, the Information Commissioner has also been instructed to review the decisions of the Home Office when the administrative review kick-started from October 2014 to date. The decision and the report of the Immigration Commissioner, Mr. Bolt, at this point will shock your mind when you see the revelation of what has happened during the period Home Office have implemented administrative review. That is where we're coming. Tice Madox Solicitors will come in. We use all the reports, all the policies, guidances, all the statutes, case laws that have chunked out there to present you, to defend you robustly in the right way and advance your cause to make sure you succeed. I don't have all the time. Time is up for me. But I remain Justice Maduforo. I am the principal of Tice Madox Solicitors, and Tice Madox Solicitors stand to represent you in your best interest. The telephone numbers are on there. Contact us on the landline, book an appointment to come and see us to table your case in a more friendly and convenient environment and advise you highly in a professional manner. Till next time I come your way, keep tuned and watch this program, Tice Madox Solicitors.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional,